Okay, this is the long-awaited corruption in the courts number 4. So let's get going. Well, first of all, PIG, the word PIG is an acronym and it stands for Persons in Government Who Intend to Breach the Trust and Perjure Their Oath. I have several YouTube videos that explain how these judicial whores use their fictitious color of law as justification for their assaults, kidnapping, false imprisonment, thefts, and murders. And some of them are the bar members video, the Canada Border Pigs video, the bankrupt corporate so-called governments video, the Fire of the United Nations Judicial Whores in Canada video, and the We Are Under Martial Law Rule video, and others. The International Criminal Court of Justice had convicted Elizabeth the Queen for crimes against humanity related to the First Nations of Canada and elsewhere, they've convicted the previous pope and the current pope, and others. And so they found mass graves of children, and so it's well deserved. It's too bad that they're going to be so hard to hunt down, but justice is going to come, you know, whether in this life or the next. We're all gonna see them in hell, quite frankly. But we'd really like to see them do that little dance they do at the end of a common law rope. When the last person in a First Nation Indian tribe dies, they announce it in Parliament because there's a trust fund, and when there's no beneficiaries, the thieves get to keep the money for their thieving bankster buddies. That's exactly what's going on. There's 358 court cases at Canley that say that they have to have the appearance of justice. And you go to justia.com and there's even more in the U.S. The appearance of justice is not justice, it's a fraud. And this is a definition about prima facie taken from Black's Law Dictionary, 5th edition. Prima facie, at first sight, on the first appearance, on the face of it, so far as can be judged from first disclosure, presumably, a fact presumed to be true unless disproved by some evidence to the contrary. See, in my video about the martial law and how we've been under martial law, everything under martial law works on color of law and presumption. Okay, they just presume that you're one of their slaves until you defeat their presumptions, and so that's why you got to have the appearance of justice, and everything is a fraud. That's the only thing they can do is fraud, and it's all coming from the Vatican. Anyways, here's a Barron's Canadian Law Dictionary, 6th edition, colorable, presenting an appearance that does not correspond with reality, or an appearance intended to conceal or deceive. Okay, and so same dictionary, Canadian Law Dictionary, Barron's Canadian Law Dictionary, 6th edition, color of law. Mere semblance of a legal right and action done under color of law is one done with the apparent authority of law, but actually in contravention of the law. And this is the the Employment Insurance Act court case in 1937, and this is the Privy Council speaking, so it went to England where it was overturned. And so there's a couple points I want to make in this case, because it says up at the top there, it says in other words, Dominion legislation, even though it deals with Dominion property, okay, so again, you have to understand that a statute deals with the property of the government. That's why when a judge is dealing with a statute, he's a clerk. He's not a judge. It's completely administrative. They're dealing with their property, with their slaves. And so that's what that's all about. And that's what that Kangaroo court with the judicial whores in my case was all about. And then it goes on. See, they're giving them the recipe. It says in the lower part that's underlined, it says it's not necessary that it should be a colorable device or a pretense. See, they overturned it, but they're giving them the recipe at the same time. And they're telling them, make it color of law. That's exactly what they're telling them. Black's Law Dictionary, 5th edition. Color means an appearance, a semblance, a simulacrum as distinguished from that which is real, a prima facie or apparent right. hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise, or a pretext. Color, colorable, I should say, that which is in appearance only, and not in reality what it purports to be. Hence, counterfeit, feigned, having the appearance of truth. Color of law means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law made possible only because the wrongdoer is clothed with authority of state is action taken under color of law. Color, this is Tomlin's Law Dictionary, 1835 edition, signifies a probable plea, but which is in fact false. It's a fraud. Color of law is when an act is evilly done by the countenance of an office and always taken in the worst sense, being grounded upon corruption, to which the office is a shadow and a color. Tomlin's Law Dictionary, 1835. Color, this is Burrow, a New Law Dictionary, an apparent or prima facie right. See, all these words, they're always using all these words. They all work together. Prima facie, an apparent or prima facie right. Remember, prima facie is at the first appearance. To give color is to admit such a right. Colors of two kinds, implied or expressed. Excuse me. Implied color is that which is naturally inherent in that color in the structure of all pleas, and confession and avoidance, okay? See, that's what they do. It's all about, all of these kangaroo courts are dealing in confession and avoidance. They get their hired thugs to go out and assault you and drag you into their kangaroo court and get you to give evidence against yourself. And it's all in what you say will determine what happens. And they're nothing but a bunch of thieves and in some cases murderers. That is, they all admit a right in the opposite party, but at the same time avoid it. That's called confession and avoidance. Express color is defined as a feigned matter pleaded by the defendant in an action of trespass for which the plaintiff seems to have a good cause of action, whereas in truth he has only an appearance or a color of cause. And that's Burleigh New Law Dictionary, 1871. Extortion, to wrest away in a large sense any oppression under color of right. It is usually implied to that abuse of public justice which consists of the unlawful taking by an officer by color of his office of any money or valuable thing from a person where none at all is due, or not so much as due, or before it is due. And that's Tomlin's Law Dictionary, 1835. And that's what these Canada border pigs, when they seized my truck and demanded extortion to get it back. That's exactly what it is. A bull is a briefer mandate of the Pope. The pimp, actually, is probably a better word, from Rome. It says here, we'll go down here, it says, and if any person shall obtain from Rome any bull or writing to absolve or reconcile such as forsake their due allegiance, or shall give or receive absolution by color of such bull. See, it's all coming from the Vatican. It's exactly where it's coming from. Tomlin's Law Dictionary, 1835 edition. This is the Declaration of Independence. And you got to understand the Declaration of Independence is basically a list of grievances. So what they say at the beginning in the preamble and in the first paragraph or two, it says, because the king has violated the law of nature and nature's God, we're telling him to take a hike. But because the respect of our fellow man is important, we're making a list and making it public. And so and this is one of the items. He's combined with others to subject us to a jurisdiction foreign to our Constitution. Gee, that sounds like martial law. Unacknowledged by our laws, given his assent to their acts of pretended legislation. And that's color of law. And pretend legislation's talked about all over the place. This is further in the Declaration of Independence. He's affected to render the military independent of and superior to the civil power. Gee, that sounds like martial law. For imposing taxes on us without our consent. Gee, that sounds like martial law. For depriving us in many cases for the benefits of trial by jury. Martial law. For abolishing the free system of English laws in the neighboring provinces. A province establishing therein an arbitrary government. Gee, that sounds like martial law. And enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule. Gee, that sounds like martial law into these colonies. He has abdicated government here by declaring us out of his protection and waging war against us. Gee, that sounds like martial law for protecting them by a mock trial. Well, gee, that sounds like martial law. That sounds like a kangaroo court. That sounds like all sorts of stuff that's happening today. Fornication. And the important part here is the first offense herein punished with 3 months imprisonment. The second was made felony in late times of usurpation by a pretended act made in 1650. And so they make these pretended acts all the time. Cowell's Law Dictionary, 1708 edition, is basically a regulation. It doesn't mean anything. It's not properly done. That's why it's called a pretended act. Judicial proceedings. And it says here, if you go on, it says, and a pretended act of Parliament for turning the books of law and proceedings of Court of Justice into English is declared to be in force. And that's Jacob A. New Law Dictionary, 1750 edition. Okay, so again, it's a regulation. It's what it is. I mean, what's that got to do with anybody else? It's an act to turn the books of law into English. So I guess they were, I don't know, some other language, maybe Latin or something, I suppose. Statute. To statutes enacted in Parliament, there must be the assent of the King, Lords, and Commons, without which there can be no good act of Parliament. Okay, so there's certain things that are required to make a lawful, valid act. And so, obviously, what they're doing is they're not satisfying all of the requirements. And it goes on. It says, but there are many acts in force, though these 3 assents are not mentioned therein. So, there's many acts in force that don't have all of the requirements required for a proper act. And they do this stuff all the time. It's color of law. It's pretend legislation. Jacob A. New Law Dictionary, 1750 edition. I've seen it all over. I searched through Arizona statutes. They do things like put emergency clauses in there. They do things like say they're going to read the bill, and it's like 2 minutes till quitting time, and so they read the bill, and then they adjourn, and then they attach the bill as part of the congressional record, and the bill is 800 pages long. Right, so they read the bill in 2 minutes, 800 pages worth. What they're doing is they're reading the title of the bill. That's not reading the bill. And they do that all the time. These customs pigs are representing you with an intent to criminally convert you into a corporation to facilitate their assaults, kidnappings, false imprisonments, and even murders in some cases. They got the guns. That's what they intend to do. They intend to use their guns. And I fired the pigs. And representation and why there's no taxation without representation is covered extensively in Corruption in the Courts 3. And it's also covered in the bar members' videos and other ones. In other words, Dominion legislation, even though it deals with Dominion property, okay, remember that's Dominion legislation deals with government property. Government legislation deals with government property, and that's in Canada. Can reference Unemployment Insurance Act of 1935, where the Privy Council overturned the act. And then if you go, next part of it here is the U.S. Constitution, Article 4, Section 3, Clause 2, says the Congress shall have power to dispose and make all needful rules and regulations respecting territory or other property belonging to the United States. And so a U.S. citizen is federal property. If you read what the court's saying, that's exactly what it is. A U.S. citizen is government property. And so that is what is regulated. This is McCullough versus Maryland, U.S. Supreme Court, 1819. All subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may be also be pronounced as self-evident. It is obvious. The sovereignty of the state extends to everything which exists by its authority or its permission. So, do you exist by their permission? Well, according to the courts, no living soul exists by their permission. And this is found in American law reports. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an unofficial entity which owes its existence and charter powers to the state, but individuals' rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And so, That's exactly what that is. And income tax, by the way, is an excise tax. Okay, it's a tax for the privilege of the corporation existing for another year. That's exactly what it is. A statute is not properly enacted in a statute that is not properly enacted is color of law. Even if a statute is properly enacted, it only affects government property. All officers acting under color of law are operating under color of office, because the statute only affects government property. All officers acting under color of office are pretenders and impersonating a public official, are in their private capacity, and are pigs. So if you have some hired thug that wants to come up and try and enforce his fictitious color of law statute on you, then he's a pig by definition. Okay? Especially if there's no breach of the peace. If there's no breach of the peace, they got nothing to say to you. Color of office: an act which is done by an officer under pretense or semblance that it is within his authority, when in truth it is not. It is said to be done by color of office, or in Latin form, color officii. This phrase implies, we think, some official power vested in the actor. He must be at least officer de facto. We do not understand that an act of a mere pretender to an office or false personator of an office is said to be done by color of office, and it implies an illegal claim of authority by virtue of the office to do the act or thing in question. And that's Abbott's Law Dictionary, Volume 1, 1879. Texas Code of Criminal Procedure, emergency clause. Okay, this is one of the ways that they do their color of law. And so the fact that the laws relating to criminal procedure in this state, and actually if you understand the law in Texas in this state means in federal areas of Texas, have not been completely revised, so they're justifying their emergency. Together with the crowded condition of the calendar in both houses, oh, it's such an emergency, create an emergency and imperative public necessity that the constitutional rule requiring bills to be read on 3 several days be suspended, and said rule is hereby suspended, and this act shall be forked and take in force and effect from after 12 meridian on the 1st day of January 1966. So what they're telling you, that's the Texas Code of Criminal Procedure. Now let's go see what it says about emergencies. Emergency does not create power. Emergency does not increase granted power, remove, diminish the restrictions imposed upon power granted or reserved. The Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and limitations of the power of the states were determined in light of emergency, and they are not altered by emergency. And that's the U.S. Supreme Court, 1934. And so what this is saying is that when they go and put that in there and they do it, it's amazing how many they do it to. Okay, I would say probably 2/3 of all the bills that are ever passed in the state legislature or U.S. Congress, at least 2/3 have an emergency clause. Okay, or they talk about emergency in some way, or they read the title of the bill instead of the whole bill. I mean, all sorts of stuff. That's why they're passing 800-page bills. I mean, think about it. There's no way at law the bill is supposed to be short. It's supposed to be brief. That's why they're supposed to read it. That's the whole purpose of making them read it, to force them to keep it short. And so, anyways, so emergency is that what that's saying essentially when they put that emergency clause in there is they're saying this code doesn't mean anything. This is absolute nullity. For anybody that knows the law, this thing doesn't mean anything, and we're just going to beat up on people that are ignorant and don't know the law. That's exactly what that's saying, is they're going to pick on people that are ignorant and don't know the law. And anybody that's smart and knows the law, then they get to get off. Most bills, approximately 3/4, passed in Texas and Arizona. I looked at hundreds of bills. And it's called the session laws. You go into the Texas session laws and the Arizona session laws, and you can look through and approximately 3/4 of them have emergency clauses. I've seen defects in state session laws, the U.S. Congressional Record, and the Hansards in Canada. They'll do things like there's 2 minutes to the end of session, and then they read the bill, and the bill is 800 pages, and yet they did it all in 2 minutes. Oh, geez, that's a magical thing. That is just absolutely magic. It's amazing how they do that. And what they're doing actually is they're reading the title of the bill only. They use emergency as justification to throw out their rules of procedure for passing legislation, and sometimes they tell you and sometimes they do not. Many times the Governor General or the President knows about the defects and refuses to sign the bill. And so then what happens is you have defects in the bill. In other words, that's why in England they're saying that it doesn't have consent or assent of the three things that are required, because they know the games these guys are playing and they refuse to do it. Another thing they do is they make their codes different than what the actual session laws say. So the session law is not the code. Okay, you got to understand that. The session law is not the code. And so it is well settled that the code cannot prevail over statutes at large when the two are inconsistent. And so the code, the provisions of the code are merely prima facie evidence of the law at first appearance. It's a fraud. And so what the code is basically a compilation of statutes. They get a bunch of lawyers, bar members. Watch my bar member video, you'll like it. Anyways, they get a bunch of bar members in a room and they go through all these session laws and the statutes at large in the federal sense, okay? In the federal government, it's called the statutes at large. In the state governments, it's called session laws. In Canada, it's called the Hansards. Anyways, in the state and federal in Canada. Anyways, so what they do is they get a bunch of bar members to go through all of these session laws or statutes at large or Hansards, and see and compile it into a code. That's what they do. An unconstitutional act is not law. It confers no right. It imposes no duties. Affords no protection. It creates no office. It is in legal contemplation as inoperative, as though it had never been passed. And that's U.S. Supreme Court. While there is no evidence before the court that Mr. Estoppel was born in Vancouver, or for that matter, he was born where he was born, the law is riddled with legal fictions. The courts may do so here, Mr. Azevedo suggests, and create a legal fiction with respect to Mr. Estoppel's name and place and date of birth. Okay, so the point I'm making here, this is Estoppel versus BC Attorney General, and they create fictions all the time. Everything they do is a fraud. It's all a fiction. And this is further on in this case. It says, in a historical introduction to English law and its institutions by Harold Potter, the learned author, at page 302, groups the fictions used into three classes. Fictions used to increase the jurisdiction of the courts. Gee, why are we surprised at that? You know, these courts, they're kangaroo courts. They're clerks, and they have no authority because there's not one they're all dealing with statutes, okay, but so they got to increase their jurisdiction somehow, and that's the reason they want to create these fictitious entities, so they can assault you, so they can justify their assaults, their kidnappings, their false imprisonments, and their murders. This is Solomon on Jurisprudence, Sweet and Maxwell, England, as a dictionary in England. Both, actually, it's a book on jurisprudence, Solomon on Jurisprudence. Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of a fictitious extension of the sphere of contract. We're talking about a quasi-contract here that's a fiction. And so they go and shove one of their fictitious contracts down your throat. A quasi-contractual action, that's why they don't want a jury, okay? That's why you will never see a jury when they're trying to shove one of these quasi-contracts down your throat, because a jury never go for this. Are you kidding? That's why it's going to be a summary trial. It's going to be a kangaroo court, because it's been prejudged from the beginning, and they're going to railroad you. Quasi-contractual action presupposes exception or retention of a benefit by one party with full appreciation of the facts and the circumstances, making it inequitable for him to retain the benefit without payment of a reasonable value. Did you know that it's a benefit to go to jail? And yes, it is, okay, because at common law there are no jails, and so common law is very severe. So they go and impose this benefit on you, and it's a quasi-contract. And that's what the pigs, the whores, Redmond and his kangaroo court, and the Canada border pigs went and conspired together, and what's his face, the attorney prosecutor, the pig, in Canada, what's his face? Boy, I'll think of his face here in a little bit. But anyways, that's exactly what they did. It is a well-settled rule of law that he who seeks the benefits of contract must also assume the burdens. Voluntary acceptance of benefit of transaction is equivalent to consent to all obligations arising from it so far as facts are known or ought to be known to person accepting. Constructive quasi-contracts are based solely upon a legal fiction or fiction of law. They have to create that fiction to get that quasi-contract going. And so there's no way that it's going to be in a common law court. Quasi or constructive contracts include obligations founded on statutory duties. It's all about statutes. See, it's all about statutes. So they go and create this fictitious color of law statute, and then they have this kangaroo court, and they drag you into their kangaroo court with their clerk and their show trial and railroad you. That's exactly what goes on. And this is taken from the Commentaries of Gaius and the Rules of Ulpian, which was translated in 1874. So this book was originally written in during the Roman Empire. And so they're talking about the underlying part is talking about except those things which perish by capitis diminutio, of which kind are a usufruct, an obligation to service on part of a freeman contracted by oath, and matters enforceable by a statutable action. And so that's why they're criminally converting your name, because it's all about statutes. They're shoving their statute down your throat so they can railroad you in their kangaroo court. Everything these judicial whores is a fraud. Once a fraud, always a fraud. Things invalid from the beginning cannot be made valid by subsequent act. These are maxims of law. A thing void in the beginning does not become valid by lapse of time. Time cannot render valid an act void in its origin. And these are all maxims of law. These bar members, both on and off the bench, deliberately convert your name into style of all block capital letters because it is color of law. And they all block capital letters, the name of the court, the name of the case. They put it in a box under the four corners rule. The four corners is the face of a written document. This phrase derives from an ancient custom, putting all instruments, such as contracts, on a single sheet of parchment as opposed to multiple pages, no matter how long the sheet might be. At common law, this custom prevented people from fraudulently inserting materials into a fully signed agreement. The requirement was that every contract should have only four corners. That's Black's Law Dictionary, 8th edition. The four corners rule is principle of documents means to gather from the entire document and not from its isolated parts. The principle that no extraneous evidence should be used to interpret it as an unambiguous document. Black's 8th edition again. And so what they do is they put it in a box because that takes it off the page. There's a YouTube channel called Servant King, and he explains very well about these judicial whores using necromancy, which bring in the dead to life, and witchcraft, which is further proof that it's a satanic religious ceremony. All bar members are priests of Baal. Watch my bar members video; it goes through it quite well. And watch Servant King. I have many wonderful friends who happen to be Catholic. Many ways that Catholic people are victims of the satanic Vatican as much as everybody else. History is riddled with examples of Vatican murdering whole communities for heresy, which is defined as any belief that they do not endorse. And so it's not changed one bit. They just become a little bit more subtle. They don't want to be caught. And we're going to go through the Jesuit oath here pretty soon, so you'll get to see the true nature of these Vatican pigs. It's all coming from the Vatican. Corruption in the Courts 3 talks more about the Vatican linked to pretended legislation. This is Jacob A. New Law Dictionary, 1750. Jesuits, etc., born in the King's Dominion and are ordained by the pretended jurisdiction of Rome. See, again, it's coming down to pretend jurisdiction. It's all coming from the Vatican. It's well documented that the Vatican is responsible for some of the worst atrocities in history. It's well documented that they used to have bisexual copulation contests in the Vatican. When the Pope came to visit Edmonton in the late 70s, they had full-page articles about some of the stuff that went on in the Vatican in the Edmonton Journal, and it talked about that stuff. The Edmonton International Criminal Court of Justice has convicted Pope Benedict of crimes against humanity, and Elizabeth the Bitch against crimes against humanity. The International Criminal Court of Justice has also convicted the most current Pope. Are we surprised when all of these Catholic priests are charged with child molestation? There are stories of dead babies being buried under convents. The negotiable instrument law is a subset of Roman civil law. Statutes are Roman civil law. Municipal law is Roman civil law. These judicial whores are operating under Roman civil law, and it's all coming from Unidroit, and Unidroit is 100 yards from the Holy See. This is taken from the commentaries of, we already talked about this. It talks about, except those things which perish by capitis diminutio, and it's matters enforceable by a statutable action. And this is more stuff from the commentaries of Gaius. Capitis diminutio is the right of agnation. The right of agnation is destroyed, but that of cognation is not changed, because the civil law doctrine may destroy civil law rights, but it cannot destroy those of natural law. So they convert you into their civil law, and then they railroad you, and you don't have access to natural law rights. Civil law, Roman civil law are all convertible phrases meaning the same system of jurisprudence, that rule of action, which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. And so this is all coming from the Vatican, and it's municipal law, and Unidroit talks about it. Black's Law Dictionary, 4th edition. Status. The position of an individual regarded a person, the constituent element of which were liberty, citizen, membership in a family, and it says civil law, and that's Wharton Law Lexicon, 1860. Status is a condition or situation. A corporation has no status as a citizen outside the jurisdiction where it was created. Anderson's Law Dictionary, 1889. Status is a condition, a legal position or condition, and that's this Rapelier Dictionary of American and English Law, 1888. Status. Question of status is important in jurisprudence because it's generally treated as a basis for the classification of law according as it applies to ordinary persons or to persons having a status, a disability, particular legal condition. See, infants, married women. See, this is all Roman civil law. It's all Roman civil law. Status, again, Black's Law Dictionary, 4th edition, is a state or condition. They're talking about status. Status, the underlined part, a person's legal condition insofar as it is imposed by the law without the person's consent, as opposed to a condition that the person has acquired by agreement, the status of a slave. Okay, so get a load of that. You agree to be a slave. By the status or standing of a person is meant the position he holds with reference to the rights which are recognized and maintained by the law. And that's why they don't want to, they want to make sure you don't have access to common law, because at common law, status means nothing. It's all Roman civil law. At common law, status means absolutely nothing. Everybody is equal under the law. Under Roman civil law, you're not equal. You're not even remotely equal. And status is everything. Law of status, it is one of 3 departments into which civil law is divided. Remember, Roman civil law is municipal law. It's all about status. Law of persons, that law which pertains to the different statuses of persons. Okay, that's Black's Law Dictionary, 8th edition. Both of those are in Black's 8th. Freeman, a person who possesses all civil and political rights belong to people under a free government. A person who is not a slave. Okay, they're talking about status. That's exactly what they're talking about. Freeman, a distinction of a freeman from a vassal, and they're talking again about status. The title of freeman, Williams Law Dictionary, 1816. Freeman in Roman law, it was one who is either born free or emancipated, who was the opposite of slave. They're talking about status, Black's 4th. Capitis diminutio is the destruction or caput of legal personality, wipes out the former individual and puts a new one in its place. And there's 3 ways the juristic personality may thus be destroyed in 3 ways. Number 1 is by loss of status libertatis. This is capitis diminutio maxima, okay? And then 2 is by loss of status civitatis, okay? So it's all about status. This is all about status. And then it's taken from a textbook in the history of the system of Roman private law. Okay, it's private law. They got to get you into a contract. And they drag you into their kangaroo court and railroad you with one of their quasi-contracts. Black's Law Dictionary, 8th edition. Capitis diminutio maxima is the maximum reduction of status. The diminution of a person's legal status as a result of being reduced to slavery. And that's exactly what these whores are doing, and they've been doing it ever from the beginning, and it's all coming from the Vatican. It's coming from the United Nations, and this all these judicial whores, and we need to get rid of them. Black's eighth, capitis diminutio in Roman law. A loss or curtailment of a man's status. That's capitis diminutio maxima, when a man's condition was changed from one of freeman to one of bondage, when he became a slave. And that's Black's fourth. Liberty and the words of the Great Charter, chapter 29. We'll go back to the, we'll go let's see here. We'll go about 2/3 of the way down, and it says, and it is enacted by 5 Edward 3, chapter 9, that no man should be attached by any accusation nor forejudged of life or limb, nor shall his lands or goods be seized into the king's hands, contrary to the Great Charter of the law of the land. You know, the thing is, this is taken from Tomlin's Law Dictionary, 1835. These pigs, and what I'm talking about is the pigs in the government that intend to perjure their oath. You know, it was within a year of doing the charter, the Magna Carta, they were encroaching again. In the U.S., you know, before 1800 even rolled around, they had the Aliens and Sedition Act, and where you said anything against the government, then you were subject to fines and who knows what. And so they lay awake at night coming up with ways where they can assault you and kidnap you and falsely imprison you. And that's exactly what's going on. Liberty, the right of personal liberty, consists of power of locomotion, the absolute right of property, inherent without any control or diminution, save the laws of the land. Okay, and so that's what freedom is all about. That's Tomlin's Law Dictionary, 1835 edition. Capacity is an aspect of status. Both are defined by a person's personal law, and so again, it comes down to, and this is taken from Wikipedia. Okay, so capacity and status work together, and so are you of capacity. Summary proceeding, Black's Law Dictionary, 4th edition. Any proceeding which is controversy settled, case disposed of, or trial conducted in a prompt and simple manner, without the aid of a jury, without presentment or indictment, or in other respects out of the regular course of common law. So a summary proceeding has absolutely nothing to do with common law, and it's a kangaroo court. That's exactly what it is, and that's what these whores did with me in Canada. These pigs. The pig on the bench, Redmond, and under the directions of Mallory and Rook and Ethel and Johnston and Harper and Elizabeth the bitch. A non-jury proceeding that settles a controversy or disposes of a case in a prompt and simple manner. We don't want to have any complications here. We don't want to embarrass the court. We just want to railroad this guy. It's a plenary action. The common law was wholly a stranger to summary proceedings. And that's Black's Law Dictionary, 8th edition. Plenary jurisdiction is a military dictatorship, a court's full and absolute power of the subject matter and the parties in this case. The summary proceedings, another name for a star chamber that was abolished in England. The corrupt star chamber courts of England required defendants to have counsel. Star chamber stood for swiftness and arbitrary power. Military law. It was a limitation on the common law. In other words, there was no common law there. That's U.S. Supreme Court. Magna Carta says these crowned pigs are not supposed to be causing us injury under any circumstances, and that's chapter 29. And it says, no freeman shall be taken or imprisoned or seized or exiled in any way destroyed, nor shall we go upon him nor send upon him, except by the lawful judgment of his peers or the law of the land. You know, I'm just having trouble here. I don't see where it says the customs pigs. Does it say customs pigs in there anywhere? I don't see customs pigs anywhere in there. Chapter 13 actually says that the customs pigs are prohibited from doing anything, because it says, in the city of London shall have all its ancient liberties and free customs, as well by land as by water. Furthermore, we decree and grant that all other cities, boroughs, towns, and ports shall have all their liberties and free customs. And so they were obviously having problems with the customs pigs in their days too. The principle that no person should be deprived of life, liberty, or property except by due process of law. did not originate in the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, confirmed on the 19th day of June 1215, declared, no freeman shall be taken or imprisoned or seized or outlawed or exiled or in any way destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or the law of the land. It has been said that the principle was known before Magna Carta and that it originally designed to secure the subject against arbitrary action of the crown and to place him under protection of the law. It is settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule of common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule of common law. And that's volume 16, American Jurisprudence, second edition, Constitutional Law, section 543. To be that statutes which would deprive a citizen of his rights of person or property without a regular trial, according to the course and usage of common law, would not be the law of the land. And that's a New York court case, North Carolina, actually. This is Taylor versus Porter. The words by the law of the land as here used do not mean a statute passed for working in the wrong. This section was taken with some modifications from a part of the 29th chapter of the Magna Carta, which provided that no freeman should be taken or imprisoned or seized of his freehold, but by the lawful judgment of his peers or by the law of the land. Lord Coke, in his commentary upon this statute, says these words by the law of the land mean by the due course and process of law, which he afterwards explains to be by indictment and presentment of good and lawful men, where such deeds are done in due manner by the writ original of the common law. And that's New York Supreme Court. This law of nature, being coeval with mankind and dictated by God himself, is of course superior in obligation to any other. It is binding over all the globe and all countries at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority immediately from this original. And that's Blackstone's Commentaries on the Laws of England. Tillman the whore says the Magna Carta is no longer relevant in some of his decisions. This same thing Tillman's whore buddy said before the Magna Carta too. That is the same thing. The law of England is divided into three parts: the common law, which is the most general and ancient law of the realm, statutes or acts of parliament, and particular customs. The common law appeareth in the Magna Carta and other ancient statutes, which for most parts are affirmations of the common law. And so tyrants throughout history have said that the Magna Carta doesn't apply. And Tillman's whore buddies said the Magna Carta was not relevant just before the Confirmio Chartarum, before the Glorious Revolution in England, before the English Civil War, before the War of Independence. These whores come out and start saying the Magna Carta is not relevant anymore. That's because they're bought and paid for. That's because they're a clerk working for their agency. That's because they're not a judge. Tillman and his handler Rook obviously intend to precipitate another war so his Vatican buddies can make some money. Tillman and Rook and their whore buddies are bought and paid for, and they intend to provide the best justice that money can buy. They're not acting as a judge, they're acting to enforce a statute. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts administering and enforcing statutes do not act judicially, but merely ministerially. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessary nullities. They're clerks. They're not judges, they're clerks. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. Officers of the court have no immunity when violating a constitutional right, for they are deemed to know the law. An officer who acts in violation of the Constitution ceases to represent the government. These judicial whores are not even representing the government. They don't have any immunity. They're just a bunch of thieves. They're imposters putting on a charade in this kangaroo court to complete their quasi-contract. An impostor, those who falsely pretend an ordinary, extraordinary commission from heaven, or terrify and abuse people with false denunciations of judgment. And that's Tomlin's Law Dictionary, 1835. It basically says the same thing in Williams Law Dictionary, 1816, and Black's Law Dictionary, 8th edition, even says, one who pretends to be someone else to deceive others, especially to receive benefits of a negotiable instrument. Imposters, people at Bernay New Law Dictionary, basically says the same thing. Abuse the people with false denunciations of judgment, and it says a bunch of other things too. Where there's no jurisdiction, there's no judge. The proceeding is as nothing, such has been the law from the days of Marshal Saya. and that's cited in a U.S. court case, but is citing Coke. Okay, void judgment is one which has no legal force and effect whatever. It is an absolute nullity. Its invalidity may be asserted by any person whose rights are affected at any time and any place. It need not be attacked directly, but may be attacked collaterally whenever and wherever it is interposed. A void order may be attacked either directly or collaterally at any time. A void judgment is one which from its inception is and forever continues to be absolutely null, without legal efficacy, ineffectual to bind the parties who support a right of no legal force and effect whatever, incapable of enforcement in any matter and to any degree. It's a void judgment. A void order results from a fundamental defect in proceedings and from a without jurisdiction ultra vires act of a public body or judicial officer. These are English court cases now that are talking about it. The without jurisdiction ultra vires act is any act which a court did not have power to do. A void order is incurably void in all proceedings based on an invalid claim or void act are also void. Even a decision of the higher courts will be void if the decision is founded on an invalid claim or void act, because something cannot be founded on nothing. An oath. All oaths must be lawful, allowed at common law or some statute. If they're administered by persons in a private capacity or not duly authorized, they are quorum, non judice, and void. That's Tomlin's Law Dictionary, 1835 edition. And what they're talking about here is that so if they're not acting, if they're not authorized to give an oath, or if they're not acting in their official capacity, then there is no oath. And that goes back to the bitch, because she wasn't sitting on the stone of scone, on the proper scone of scone, and we talk about that in the de facto courts video. And so none of them have a valid oath. Matter of fact, there's that if they're Masonic, you know, how many of them are Masonic or Jewish? And so listen to what this oath of Kol Nidra, which is Jewish. All vows, obligations, oaths, anthems, were ever called Conan, Konas, or by any other name by which we may be found from this day of atonement unto the next, we do repent. May they be deemed dissolved, forgiven, annulled, and void, and made of no effect. They shall not bind us, nor have any power over us. The vows shall not be reckoned vows. The obligations shall not be obligatory. Their oaths shall, nor the oaths be oaths. And that's found in the Jewish Encyclopedia, Volume 8, on page 539, and also in the Revised Festival of Prayers, published in 1919 by the Hebrew Publishing Company in New York. And now let's see what the Masons have to say about it. Whenever you see any of our signs made by a brother Mason, especially the grand hailing sign of distress, you must always be sure to obey them, even at the risk of your life. If you're on a jury and the defendant is a Mason and makes the grand hailing sign, you must obey it. You must disagree with your brother jurors if necessary, but you must be sure not to bring the Mason guilty, for that would be disgrace upon our order. You must conceal all crimes of your brother Mason except murder and treason, and these at your own option. Should you be summoned as a witness against a brother Mason, be always sure to shield him, prevaricate, don't tell the truth in this case, keep his secrets, forget the important points. It may be perjury to do this true, but you are keeping your obligations, and that's found on page 183 of the Masonic Handbook. Perjury. This is taken from an Encyclopedia of Freemasonry in 1916 edition, volume 2, page 555 to 556. And it says here, perjury in municipal law, perjury is defined by the willful false swearing to a material matter when an oath has been administered by lawful authority. So again, remember we talked about lawful authority. Now let's go to the underlined part. It says here, the old Romans seem to have taken a sensible view of the crime of perjury. Among them, oaths were not often administered, and in general, a promise made under oath had no more binding power in a court of justice than it would have had without the oath. False swearing was with them a matter of conscience, and the person who was guilty of it was responsible to the deity alone. And so, again, these pigs intend to railroad you, and the truth has nothing to do with anything. They just want to get you in their kangaroo court and assault you with their statutory fictitious law and impose one of their quasi contracts on you. That's exactly what it's all about. And and this is the Jesuit oath, okay? And this is going to be going over several pages here, but you're going to like this. It says, Superior speaks. And this is all taken from the U.S. Congressional Record, I might add. Anyways, Superior speaks. My son, heretofore you have been taught to act the dissembler among Roman Catholics, to be a Roman Catholic, and to be a spy even among your own brethren, to believe no man, to trust no man among the reformers, to be a reformer, among the Huguenots to be a Huguenot, among the Calvinists to be a Calvinist, among the Protestants generally to be a Protestant, and obtaining their confidence, to seek even to preach from their pulpits, and to denounce with all vehemence in your nature your holy religion and the Pope, and even to descend so low as to become a Jew among Jews, that you might be enabled to gather together all information for the benefit of your order as a faithful soldier of the Pope. Yeah, get a load of this. This is real juicy stuff, eh? This is actually taken from the U.S. Congressional Record. And it goes on. You've been taught to insidiously plant the seeds of jealousy and hatred between communities, provinces, states that were at peace, and incite them to deeds of blood, involving them in war with each other, and to create revolutions and civil wars in countries that were independent and prosperous, cultivating the arts and the sciences, and enjoying the blessings of peace. To take the sides with the combatants, and to act secretly with your brother Jesuit, who might be engaged on the other side, but openly opposed to that which you might be connected, only that the church might be the gainer in the end, in the conditions fixed in the treaties for peace, and that the end justifies the means. You have received all your instructions heretofore as a novice, a neophyte, and have served as coadjutor, confessor, and priest, but you have not yet been invested with all that is necessary to command in the army of Loyola in the service of the Pope. You must serve the proper time as the instrument and executioner as directed by your superiors. For none can command here who has not consecrated his labors with the blood of the heretic. For without the shedding of blood, no man can be saved. Therefore, to fit yourself for your work and make your own salvation sure, you will, in addition to your former oath of obedience to your order and allegiance to the Pope, repeat after me. And then now he starts to repeat. Now in the presence of Almighty God, the Blessed Virgin Mary, the Blessed Michael the Archangel, the Blessed St. John the Baptist, the Holy Apostles, St. Peter and St. Paul, and all the saints and sacred hosts of heaven, I furthermore promise and declare that I will, when opportunity present, make and wage relentless war secretly and openly against all heretics, Protestants, and liberals, as I am directed to do, to extirpate and exterminate them from the face of the whole earth, and that I will spare neither age, sex, or condition, and that I will hang, waste, boil, flay, strangle, bury alive these infamous heretics, rip up the stomachs and wombs of their women, and crush their infants' heads against the walls, in order to annihilate forever their inexorable race. That when the same cannot be done openly, I will secretly use the poisoned cup, the strangling cord, the steel of the poignard, the leaden bullet, regardless of the honor, rank, dignity, or authority, the person or persons, whatever may be their condition in life, either public or private, as I at any time may be directed to do so by any agent of the Pope or superior of the Brotherhood of the Holy Faith of the Society of Jesus. In confirmation of which, I hereby dedicate my life, my soul, and all my corporal powers, and with this dagger which I now receive, I will subscribe my name written in my own blood in testimony thereof. And should I prove false or weaken in my determination, that may my brethren and fellow soldiers of the militia of the Pope cut off my hands and my feet and my throat from ear to ear, may my belly opened and sulfur burned therein, with all the punishment that can be inflicted upon me on earth, and my soul be tortured by demons in the eternal hell forever. All of which I do swear by the blessed Trinity and blessed sacraments, which I now to receive, to perform, and on my part to keep inviolable, and to do call all the heavenly and glorious host of heaven to witness the blessed sacrament of the Eucharist, and witness the same further with my name written with the point of this dagger dipped in my own blood, and sealed in the face of this holy covenant. And this is taken from the book Subterranean Rome by Charles Didier, translated from the French and published in New York in 1843. Dr. Alberto Rivera escaped from the Jesuit order in 1967, and he describes his Jesuit oath in exactly the same way as appears in this book. The Jesuit oath of induction is also recorded in the Congressional Record of the U.S. House of the USA, House Bill 1523, contested election case of Eugene C. Bonnewell against Thomas C. Butler, February 15th, 1913, at page 3215 to 3216. So this is in the congressional record. This is taken from the Treaty of Peace. The United States is not Christian. This is taken from the Treaty of Peace, Article 11 of the Treaty of Peace and Friendship between the United States and the Bey and subjects of Tripoli, of Barbary, November 4th, 1796. As the government of the United States of America is not in any sense founded on the Christian religion, and it goes on and talks about a few things here. So the federal government is not Christian. I've filed several criminal complaints under oath against these Canada border pigs and their handlers in the Canadian federal corporate so-called government and the provincial corporate so-called government. Estoppel is a bar that prevents one from asserting a claim or right that contradicts what one has said or done before or what is legally established as true, and that's Black's Law Dictionary 8th edition. Estoppel certificate is a signed statement by a party such as a tenant or mortgagee certify for the other's benefit that certain facts are correct, that a lease exists. A party's delivery of this statement stops that party from later claiming a different set of facts. That's Black's Law Dictionary. Estoppel by silence. Estoppel that arises when a party is under duty to speak but fails to do so. The principles of estoppel apply against the state as well as individuals. The documents recorded into the public in the county recorder's office or part of a lawsuit that they were served with is on file at the courthouse, and so they have constructive notice. There's copies of the recorded documents that were served on the respondents. Constructive notice is notice arising by presumption of law for the existence of facts and circumstances that a party had a duty to take notice of, such as a registered deed. Remember, these are recorded with a Pinal County recorder or a pending lawsuit, and so some of them are filed. Notice presumed by law to have been acquired by a person and thus imputed to that person. That's Black's 8. Record notice, constructive notice, contents of an instrument such as a deed mortgage that has been properly recorded. Again, these are recorded documents or filed with the court. So I filed criminal complaints. There's an affidavit of criminal complaint, the criminal corporation called Canada, which is recorded with the Pinal County recorder here. There's also a solemn asseveration of criminal complaint, Rob Nicholson, Victays, and Hired Thugs, which is recorded with the Pinal County recorder. There's also a solemn asseveration of criminal complaint, Alberta Court of Appeals, which is recorded with the Pinal County recorder. There's also a solemn asseveration of criminal complaint, Alberta Solicitor General, which is recorded with the Pinal County recorder. There's also a solemn asseveration of criminal complaint, Elizabeth the Bitch and her Hired Thugs, which is recorded with the Pinal County recorder. And so this is actually taken from the this criminal complaint 2012-061-165. So that's Elizabeth the Bitch. And attached to that, this is taken from it, and it was attached to this notice of demand, and the package sent by registered mail was the petition of right. So she had the petition of right, was this affidavit of criminal complaint to the Criminal Corporation of Canada, and was the affidavit of criminal complaint and claim of right, the Lethbridge City Police, and was a counterclaim and asseveration of criminal complaint, Alberta Solicitor General, and a solemn asseveration of criminal complaint, the Alberta Court of Appeals. So those were all served on the bitch, and so she knew fully what was going on. And that was in chapter 22 of that criminal complaint. In chapter 39 of the criminal complaint, I said that Canada is only Admiralty Maritime Law without lawful authority, and it's even coming out of their own Interpretation Act. In every enactment, for greater certainty, Canada includes the internal waters of Canada, territorial sea of Canada, and this is consistent with what the courts are saying. The law of Congress, this is a U.S. Supreme Court case. The law of Congress do not extend in the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. And the exclusive jurisdiction of the United States having forts and dockyards ceded to them is derived from the express assent of the states by whom the cessions were made. And it derives in no other manner, because without it, authority of the state would be supreme and exclusive therein. And then I even added in, I said, But these criminals, Elizabeth and her hired thugs, and I got a bunch of other people here, and their hired thugs each know they have no authority on the land of Alberta. Each of them intend to bear false witness to their oath by shoving their collar of law down my throat and the throat of people they know they have no authority over. So that's in the criminal complaint, and that's recorded. And when they assaulted me, they proved. Remember, what I did is I made that statement under oath. I filed it into the public, and then I served them with a copy, and they proved. When they assaulted me, they proved that that's true. That's exactly what happened, okay? The only way that they cannot deny it, they could have filed something in there saying that's not true, but they didn't do that. They had time. They could have responded and filed something into the counter recorder, into the public somewhere saying that's not true, but they didn't do that. And so, and then when they assaulted me, they proved that it was true. They proved that it was 100% true, and that's exactly what happened. And so then this is further on, paragraph 110, and they intend to criminally convert my citizenship and me into an incorporation in order for them to facilitate the violation of my rights by unlawfully arresting me, assaulting me, kidnapping me, and to facilitate my murder when I exercise my right to resist their unlawful arrest. And each of them are engaging in treason, sedition, perjury of oath, all of which is under the color of law and further. And Tillman, the whore, even admitted in his show trial, or in the hearing for the prohibition, that it was color of law. And so they knew exactly what's going on, and they proved that that statement is 100% true, and they intend to do it. And the fact that they went and had this lookout notice in their computer system. Anyways, these in paragraph 103 have intentionally perjured their oath, are engaged in treason and sedition by forcing their martial law under me with the force of arms. Their thugs are doing exactly the same thing that precipitated the Magna Carta and the War of Independence, and they intend to precipitate another war. It's proof that these perjurers intend to criminally convert my citizenship, my name, facilitate the violation of my rights by unlawfully arresting me, assaulting me, kidnapping me, and even murdering me, and engaging in treason, sedition, and perjury of oath, all of which is under the color of law. And Nicholson and Taze are cowards, and they'll never meet me face to face because they're cowards. And they'll send their pig thugs out to assault me, and that's exactly what they intend, and they proved it when it happened. And it was after I filed this document and after I served them with a copy. I'll make sure I have a butcher knife available to exercise my right to defend myself from their unlawful arrest. And we all know how they like to take everybody's guns so they can murder them easier. And so, anyways, this is actually found in paragraph 109. It says here, Rob Nicholson, Attorney General of Canada, is giving aid and comfort to the enemy and is an impostor operating without authority under the color of law, and none of his judgments, orders, or any force in effect. He's in criminal violation by knowingly, intentionally conspiring with criminals to criminally convert my address and my citizenship, and has violated his bond, his corporate charter, and violation is a breach of trust which was established with the people of Alberta against the peace and dignity of the people of Alberta. It is ordered that his bond be arrested and he be arrested and prosecuted for treason in time of war, giving aid and comfort to the enemy, sedition, misprision of felony, extortion under color of office, theft by conversion, criminal conversion, perjury of oath, theft, obstruction of justice, extortion, unlawful arrest, false imprisonment, assault, murder, racketeering, and conspiracy to commit the above-mentioned crimes. And this is basically a standard paragraph I put at the end, although if some of it doesn't apply, I take it out and I may add in a few things, but generally, you know, it's pretty standard. And this victase, there's the same thing, okay? So it basically goes through and says the same thing. I won't read it to belabor the issue, but there's the one for victase. That's 109 and that's 110. And so similar statements against victase is in the asseveration of criminal complaint, which is this other one, okay, this 2012-022428. See, the other one was, oh yeah, that's it there. And then similar statements are in J.C.B. McDonald and Langston and Catherine Fraser and Alison Redford and McCurdy and Nicholson and victase and Barry Benkendorf in this criminal complaint, the Alberta Court of Appeals. which is a totally separate document that was done in 2011. Similar statements against Alison Redford, Barry Benkendorf, Rob Nicholson, Stephen Harper, David Johnston, J.D. Rook, N.C. Whitman, Tim Grubb, Tom McKenzie, Doug McLaughlin, James Langston, Nancy McCurdy, L. Christos, T. Ramakowski, R. Sparrow, Robert Coleman, J. Delaney, Robert Frank O'Burl, Brad Pickering, and Mr. Price are in the affidavit of criminal complaint in the corporation called Canada, which was a separate one recorded in 2011. And similar statements made against Delaney, O'Burl, Pickering, Stelmach, Ethel, Harper, Johnson is in the criminal complaint against the Solicitor General, which was also done in 2011. Similar statement against Tom McKenzie, McLaughlin, Christos, Ramatowski, Sparrow, Robert Coleman, Rook, Redford, Whitman, and Grubb was in the affidavit of criminal complaint, Lethbridge City Police, which is recorded with the Pinal County Recorder also. There's criminal complaints were attached to the petition of right, which was filed in November 10. There was an affidavit of criminal complaint, Lethbridge City Police. There was an affidavit of criminal complaint, Lethbridge City Police, 09-2010. And that one named Tom McKenzie, Doug McLaughlin, L. Christos, T. Ramatowski, R. Sparrow, Robert Coleman. There was an affidavit of criminal complaint, Lethbridge City Police, 10-2010, and that one named Tom McKenzie, Doug McLaughlin, L. Christos, Tim Ramatowski, R. Sparrow, Robert Coleman, J.D. Rook, Alison Redford, N.C. Whitman, and Tim Grubb. And the affidavit of criminal complaint, the Canada Border Services Agency, that's the Border Pigs, and Rob Nicholson, the affidavit of criminal complaint. And the facts that the Canada Border Pigs had their lookout notice in the computer system is proof that they conspired to assault me, kidnap me, and falsely imprison me. And all of this was in the criminal complaints that were filed in the Lethbridge Court of Queen's Bench as part of the petition of right that I filed, as well as the criminal complaints that were filed with the Pinal County Recorder as described herein, and the Canada Border Pigs video and the Fire of the United Nations Judicial Horse in Canada video. My case of the Canada Border Services Agency pigs was prejudged from before I even got to the border by the judicial whore pigs Rook, Tillman, Matchett, Redmond, working in their de facto United Nations so-called court. It was a summary trial, which is a kangaroo court, in which I was denied my right to trial by jury of my peers under their United Nations rules of procedure, which are designed to deny any justice. Matter of fact, they even say they got to have the appearance of justice, which is a fraud. These judicial whores intend to deny me due process, and I was denied due process from the beginning. This is all under instructions from Elizabeth the bitch and the pigs Johnson, Ethel, Harper, and others. At common law, the jury has to be your peers. At common law, the jury calls the witnesses, questions the witnesses, determine the law and the facts in the matter, and even pronounce a sentence if necessary. At common law, the jury can disregard the law. It's called jury nullification. They can say, we don't even pay attention to statutes, and they don't. At common law, the jury can do literally anything it wants. The modification, this is part of my Fire the Whores campaign. The modification of these de facto so-called judges is not for justice, but for the appearance of justice, which is this presentation's all about. They intend to create business for their so-called court to justify their existence, to create for their de facto buddies, to collect more royalties, to get promoted to the Court of Appeals or to the Supreme Court. They create for their work for their buddies by making their decisions as cryptic as possible, by forcing the issue to another hearing, ignoring the law, and thereby forcing an appeal. We talked about the YouTube profile of Servant King, and he explains how the court case is a satanic religious ceremony and it's witchcraft. Do you want to place your future in the hands of a United Nations whore who wants to sit on the bench and play stupid? Do you want to put the future of your wife and children in the hands of one of these judicial whores that have complete immunity no matter what? Because if you sue one of them, you have to get one of their whore buddies to do it. Sure, some of them might really want to do justice, but you're going to take the chance that you got a good one, and the good ones are few and far between. Do you want to place your future in the hands of a whore that is bought and paid for by these crown pigs? Do you want to place your hands in the judicial whore, place yourself in the hands of the judicial whore who's intent on converting you into a ward of the court and imbecile? Do you consider yourself Christian? Do you try to follow the golden rule? Do you treat others the way you want to be treated? Do you think you'll get any sympathy from God on Judgment Day when you do not have done everything you can to put a stop to these satanic judicial whores selling their justice? Karma is the universal principle of what goes around comes around. If we knowingly allow these judicial whores to victimize tens of thousands of people in the name of their satanic religious ceremonies, don't you think that we'll be held accountable? Don't you think it will come back around at us? Don't you think it's already coming back around at us every day when they sell their justice in their de facto so-called courts, when their revenue officers masquerading as police officers unlawfully arrest us for commercial crimes like speeding, when they deny us due process based on one of their quasi-fictitious quasi-contracts, when they populate their prisons with victimless crimes. All judges are foreign agents of the Vatican. See the bar members video. This idea of separation of church and state was really about taking Christianity out of government and displacing it with satanic Roman civil law from the Vatican. All so-called court cases are actually satanic religious ceremonies by priests of Baal. Under the guise of separation of church and state, they've taken the Lord prayers out of the schools, they've taken Christian symbols out of the courts, they've taken Christian symbols out of the schools, they've converted our Christian government into satanic government. It's all been done by court rulings by priests of Baal masquerading as judges. At common law, there's no prisons. That's why common law is so severe. It's got to be settled right now. It's literally an eye for an eye and a tooth for a tooth. All prisons are commercial. Most of the people in prison are in there for victimless crimes. We need to fire the whores and end the tyranny of these de facto United Nations courts and their Vatican judicial whores selling their justice. Our court is only a jury of our peers, and we're all being denied it so these judicial whores can populate their prisons and collect their royalties. We need to work together to bring these whores to justice, these whores. I would like to see some of these whores do that little dance they do at the end of a common law rope, and I'm glad it's up to a jury of the peers and not me. Upcoming events, there's going to be one on citizenship, color of law, fire the United Nations judicial whores in Texas, city of Fort Worth pigs, city of Grand Prairie pigs. Copies of these documents can be found at my private group. I've got other YouTube videos, and so if you see this one, you've probably seen some other ones, but my profile is Sovereign Living, and you can send me an email and if you want to get copies. I appreciate you taking the time to listen to my little rant today, and I hope you have a real nice day.